Good morning. Thank you. You may be seated. We're here this morning in BNSF Railroad Company versus Seats Incorporated. Our case number is 1CACV140002. We have conferenced this matter already. We're familiar with the facts. We look forward to hearing from you. We'd ask you to identify yourself and your client when you begin your argument. Each side has 20 minutes. The appellant will be responsible for reserving whatever time you wish for rebuttal. These proceedings are being audio and video recorded, and we look forward to your argument. Thank you. You may proceed.
May it please the court, my name is Bill Thorpe. I represent BNSF Railway Company. The issue before this court is whether the Locomotive Inspection Act preempts a state law claim based solely on a violation of the federal law standard established by the Locomotive Inspection Act itself. And I submit to this court the following. Number one, this is a blank slate as far as Arizona law is concerned. Number two, the highest decisions from the highest courts that have considered this issue have found in favor of the position BNSF is advancing here. In the course of our opening brief, we discussed the Ingval case, which is a case from the Supreme Court of Minnesota, en banc, 2001 case, analyzed this area very, very thoroughly. Lengthy case, much cited, and it came to the conclusion that yes, indeed, there was a railroad in our situation had a claim for contribution and indemnity against the manufacturer arising out of the federal standard established by the Locomotive Inspection Act. 3 weeks after we filed our reply brief, naturally, the highest court, federal court to ever ruled on this issue, the Third Circuit, came down with a decision that we supplemented our briefing with. That is, with all due respect, the biggest case that analyzes the entire law in the area. The Third Circuit in that case, which is called Delaware and Hudson versus Noodler Manufacturing, so I'm just going to try to call it Noodler, addressed virtually every case and every argument that is in the briefing before this court. It is a very detailed opinion. It walks through the entire analysis and leads completely to the conclusion that we're urging here. The court addresses the two United States Supreme Court cases that deal with Locomotive Inspection Act preemption, which are the Kearns case and the
Napier.
Excuse me?
Napier.
Yes, the Napier case. Yes, I'm sorry, Your Honor. The Napier case. And they just say straightforwardly, Napier and Kearns do not address the issue before this court today or before the Third Circuit. And so they go forward and address it. And there's no real claim. A close reading of Kearns surely shows that the Supreme Court in that case was very concerned with just addressing state causes of action and state standards of care. The language is very careful in Kearns not to talk about whether a federal standard could be applied and give rise to a cause of action. So the holding of the Noodler court is very crystal clear. And if I could take just 1 second, it says the appellees incorrectly read Napier and Kearns to say that all state claims regarding the design and manufacturing of locomotive equipment are preempted by the LIA. But those decisions do not speak so broadly. They are explicit in holding and only holding that a state may not impose its own duties and standard of care on the manufacture and maintenance of locomotive equipment. The question left unanswered by Napier and Kearns is whether the LIA preempts a state claim that is premised on a violation of the duties and standards of care stemming from the LIA itself. In other words, whether a state claim based on federal standard of care is preempted. We conclude that it is not. And that is the decision from the highest court of appeals, the only court of appeals, federal court of appeals that has addressed this issue. And I submit that the reasoning is rock solid when you look at the other things that they consider in connection with this.
Could I ask you just a question in terms of, is there any other remedy for the railway company, if not in this forum? Is there any other forum? Do you run into the same issue? Is there any other mechanism for the railway to pursue any kind of relief?
There is no other legal mechanism that we can seek indemnity or contribution from seats. And that's why this mechanism exists. And that's why if you look at the Ayers decision, which is the United States Supreme Court decision, that discusses the FLA, it talks about contribution actions and indemnity actions that railroads can bring against manufacturers. And it specifically cites in two separate occasions to the Ingvall decision, which we believe lends a lot of support to the notion that the United States Supreme Court has already looked at Ingvall and said, yes, we understand that that's a good decision, and that shows a pathway that a railroad can pursue in order to obtain indemnity and contribution against a manufacturer in circumstances exactly like these.
Could the railway have brought an independent action against seats?
I think, Your Honor, well, we could have perhaps brought an independent action for indemnity following an adverse judgment, but it would have looked exactly like this. In other words, it would have identified the standard of federal standard of care. And the quirk in this, Judge Swan, is that in terms of the contribution, in this little-known provision in Arizona's UCATA, under 2506D and E, it specifically calls out that in an FELA action where a railroad wants to bring a contribution or indemnity claim, it has to bring the contribution claim in the FELA case.
Oh, I understand, but I guess
So procedurally, we can't pursue a contribution claim in Arizona court except in the context of this proceeding.
Sure, but if there had been no injury and the railway just didn't like the seats, or it bought some paint for its cars that had peeled prematurely, it could sue the manufacturer, right?
It could sue the manufacturer for a breach of contract or something like that. The
Breach
issue,
of warranty?
or a breach of warranty, but the issue simply.
I'm not suggesting these
Yeah.
are identical claims.
Right.
I'm just exploring the limits.
Yes.
Okay.
I mean, I think if we purchased a product and the product was in some fashion out of compliance with a warranty that had been given, we would certainly have a claim in that regard. But the issue here is whether we have a claim for indemnity and contribution arising out of a violation of the Locomotive Inspection Act. And the answer to that from both the Minnesota Supreme Court and the Third Circuit, and it's a strong hint from the Supreme Court in Ayers, is yes. And that under the provisions of the UCATA relating to a contribution claim that BNSF has to bring in connection with the FELA claim brought against it, this is the only forum in which it can be brought. That was the judgment of the Arizona legislature when it adopted UCATA. So let me just touch on a few other things. I could take a slow walk through the Noodler case, but it really does simply address every single claim that Seats in this case has thrown up against the notion that Ingvall has correctly decided. Frankly, Noodler itself is a case involving a claim against a seat manufacturer. It could not be more on all fours than where we are. And like I just read, it explicitly finds that against a seat manufacturer in these circumstances, yes, the railroad has a claim. The Seats throws up a number of cases, primarily district court cases, that seem to apply or that address some of the issues in this case. But as we went through in our brief, Most of those do not really squarely address the issue of whether a railroad can pursue a federal-based claim for relief. And if you look at footnote 15 in Noodler, they take those same cases that Seitz talks about and distinguish them, frankly, essentially on the same grounds that we do, but in perhaps a little bit more detail. Just showing that those cases do not really address the issue of whether a federal standard claim can be brought by a railroad. And if so, quite frankly, the only cases that really talk about a federal claim for relief that they cite are two. One is called Roth, and it's a district court opinion. And Roth goes off on the issue that it's brought by a railway worker, and Roth doesn't really go off on the issue before this court. It goes off on the issue, well, Roth was a railroad worker, and he could bring an LIA claim in the context of bringing an FELA claim. Roth acknowledged that the rest of the world, non-railroad workers, could bring an action based on a violation of the federal standard of care set forth in the LIA. So Roth actually supports the position we're advancing here. The other case is a case out of the Court of Appeals of Indiana called Motive Power versus Union Pacific. And it simply says, it analyzes Ingval and just says, you know, we just disagree. It doesn't really provide any analysis as to why it disagrees. And I just think they got it wrong because they didn't do any real analysis of what preemption's all about and what the Locomotive Inspection Act is all about. It's about two things. Locomotive Inspection Act is about making sure that there are certain safety features that are incorporated into locomotives, number one. That protects railroad employees. Number two, it's about protecting railroads from a patchwork of legislation and regulation so that a railroad, as it operates from state to state or municipality to municipality, doesn't have to add on or take off different kinds of equipment or be out of violation with the applicable local rules or regulations. So LII protects both railroads and railroad workers. There is nothing, and so that's the congressional intent, is national uniformity, as all the cases talk about, is one thing, and safety. Allowing this case to go forward on the basis on the claim against Seitz absolutely enhances Congress's goal of national uniformity and employee safety. Applying a federal standard by definition is a national standard. So applying a federal standard does not do anything to destroy confidentiality, national uniformity. And making sure that the manufacturer can bear some responsibility legally for manufacturing a product out of compliance with the LIA enhances employee safety. After all, placing the ultimate legal burden on the manufacturer of a product to enhance consumer safety is the notion behind our entire strict liability system. That kind of analysis should also apply here, that it enhances the
State, that's a body of state law.
Well, it's a body of state law, but I'm just saying the concept of enhancing safety by enforcing this federal regulation and placing it on the manufacturer, that should, so I'm not conflating those.
This doesn't really enhance safety, though. I mean, this allocates risk, right?
And it certainly allocates risk. It does. But it also gives the manufacturer some skin in the game, Your Honor, to make sure that the product does comply with the LIA.
Counsel, do you know whether the Nodler case, there's a petition for cert that was filed or was pending?
I do not know whether, well, I know that it has not been. I know the time for filing a petition for cert has not expired. I know a petition for review en banc was filed and denied.
Okay, thank you.
Pretty resoundingly. So that's the status. There are no, I might point out, there are absolutely no other Court of Appeals decisions on this issue, and none of them certainly that are contrary to Knoedler. So I have some issue as to really what the viability of any petition for cert would be. That
Well, there was a dissent.
there was a dissent. And let me address that, if I could, for a minute. Let me talk that dissent by Judge Hardiman, because he says, Hardiman agrees, number one, Kearns does not answer this question. He says that right out of the chute. But he says, I sort of think that Kearns suggests an answer. And he says that he thinks it suggests that he dissents for three reasons. He says that applying preemption in this kind of situation is consistent with the purpose of the LIA of solely protecting railroad workers. And as I just indicated, he's just wrong on that. The LIA isn't designed solely to protect railroad workers. He says it's not designed to do anything for railroads. That's just wrong. Because it's absolutely critical to railroads that they have national uniformity and that they have one method of operation that they're held to, one standard which they're held to across the nation. And enforcing this standard, we believe, protects, as I discussed with Judge Swan, we believe it helps protect employee safety as well. Judge Hardiman says the second reason he thinks that preemption should apply is because Kearns and Napier do not suggest the remedy we seek here. And he's right about that Kearns and Napier do not address this issue, but that's simply because they're silent on the issue. In the Supreme Court in Ayers, absolutely cited approvingly twice to Ingvall, which we suggest indicates that the Supreme Court understands that this is an appropriate path to pursue a contribution and indemnity action, because that's what they cite this case, that's the proposition for which they cite Ingvall. So the Supreme Court is not entirely silent on it. Secondly, there's a whole line of Safety Appliance Act cases, which are, and the Safety Appliance Act and the Locomotive Inspection Act are in many respects very much considered sort of two different aspects of the same coin, where the Supreme Court, and there's a line of cases that we cited, Tipton and others, which say, yes, of course there's a claim for relief, a cause of action based on a violation of the federal standard of care set forth in the Safety Appliance Act. And there's no reason at all to believe that there is any difference between an action based on a violation of the federal standard under the Safety Appliance Act and one for a violation of the Locomotive Inspection Act. There's absolutely no rational basis for distinguishing between those two field preemption kinds of cases. And the third thing he says is that it threatens national uniformity. That's his third basis. And he says, well, that will mean that state court juries are applying this federal standard, and that will result in destroying national uniformity. Two issues. Number one, how can that be? They're all applying the same standard, which is a federal standard. Number two, state court juries do that all the time right now, because a violation of the Locomotive Inspection Act is per se negligence in a Federal Employers Liability Act. That means in cases, including this one, where there's an allegation that there's a violation of the Locomotive Inspection Act, the jury is asked to find, was the Locomotive Inspection Act violated? And those cases are tried in state courts because there's concurrent jurisdiction under the FVLA, and they can't even be removed. So we try cases all the time, like I say, including this one, where the issue put to a state court jury will be, was the Locomotive Inspection Act violated? Was that federal standard of care violated? So to the extent that there is a chance that state court juries applying the LIA will result in some kind of disruption of national uniformity, that threat already exists. But let me suggest to you that that's never been expressed anywhere as a concern, that FVLA juries are applying the LIA, and that's disrupting national uniformity. And secondly, as I point out, It's a federal standard. It's the same standard. It's the standard Congress gave. Whoa, I've got 1 minute. I'm going to save 1 minute of my time.
Thank you.
Bill, Casey, this is just going to be, I have that chart over here, and so that's exactly what's over here in case you can't see that. Thank you, Your Honors. My name is Scott Jameson, and I'm the attorney for Seats, Inc. I want to address some of the questions that were raised in the first panel. As far as the Needler case, and it is Needler and not Nodler, and I didn't know there's one of the one of the counsel for Needler is from Columbus, Ohio, my same town, and I have spoken with him, and he told me it's Needler because you got to remember you need their locomotive seats. So it is Needler, and he has told me that they are planning to file an appeal to the United States Supreme Court. Judge Catani asked, is there any other remedy for the railway? And first, I want to look at the Judge Sotomayor dissent, because in deciding Kearns, you had railway workers who had worked on locomotive component parts, and they had asbestos in it. And the plaintiff had worked there and said he had been exposed to asbestos in these locomotive component parts. And he filed design defect and failure to warn claims. And the judge and they agreed that those were still preempted. And they were preempted even though this meant no remedy for the decedent and his widow. As Judge Sotomayor said...
Different though here with where you're imposing an additional requirement that you can't use asbestos in seats, whereas in this case there is a requirement that you have seats that are securely attached.
Well, the requirement, this is the problem if you start going down this road of saying there is no LIA preemption. This is the foundational statute of the LIA right here, 49 U.S.C. 20701. And this is, it says the railroad carrier is under a duty for all the locomotive parts and appurtenances to make sure they are in proper condition and safe to operate without unnecessary danger or personal injury. That's the foundational statute. So if you are going to gut LIA preemption and saying there is all you have to do is say there's a violation of the LIA, courts have been saying this standard is so broad that any plaintiff or any railroad could bring any negligence action, any product liability action, and simply say there has been a violation of the LIA in this very broad standard. And this is best, one of the supplemental authorities that we cited was the Bonner decision.
Well, stop. Is it your contention that the federal standard is too broad, or do I infer from the highlighted portions of your chart below that your problem is that they're alleging state law claims instead of the federal claims?
And courts have gone back and forth on this as to why this creates such a hornet's nest. This is, as the Bonner case said, and that district court said, if we start allowing LIA violations, any LIA violation to be permitted as a negligence per se claim, all you have to allege is this. And they say that is a completely nebulous standard. You would have juries, state court juries, and not only injured locomotive employees, but railroads would say, well, your component manufacturer violated the LIA because they provided a product that is, the condition is not safe to operate and it's unnecessarily dangerous.
Sounds a lot like product liability.
Well, and that's state tort liability, going from state to state.
But does it have to be? But does it have to be? If the claim here is one for contribution or indemnity under the federal substantive standard, and not an independent state product liability law claim. Where's the problem? It doesn't seem to me that there's any indication in the statute that Congress intended to allocate risk to a single party in the act. The extent of the preemption is to prevent states from prescribing different substantive standards that could create a patchwork of liability.
Well, you will have state court juries getting different results based on a simple allegation of this. And
Don't federal juries get different results?
Huh?
Don't federal juries?
Well-
They draw from the same pool. There aren't
Why?
federal
But
citizens.
we're dealing with locomotive component manufacturers, which have a special place for preemption. And the Supreme Court, since Napier and Kearns, have held the Locomotive Preemption Act occupies the entire field.
Napier's much easier with it. It has an additional requirement. It says you have to have a lock on a firebox, or there's a requirement that you have a curtain between rooms. That's clearly a state law. That's an addition to that's not a uniform law that's being applied, and it makes sense to say you can't have a different requirement in those situations. But here aren't they just arguing you violated the federal standard?
Well, they're trying to condense it to just saying you violated a federal standard. But if you look on down, it gets more complicated than that. First of all, as you go down, that's the LIA, and the LIA does not create a private right of action. And everybody has agreed to that. I have cited even BNSF in their response brief below says it is importantly the LIA does not create a private right of action.
But amidst all this preemption, the FELA allows actions in state court.
That is correct, because the FELA only has to do, it can only be brought against railroad carriers. That has to do with their maintenance and inspection. That's not contemplated for design of component manufacturers.
So is the core of your position then preemption or immunity?
It's tied together because as the courts have said, when you get to, since we cannot be sued, there is no private right of action. Mr. McKinney could not have sued us because he has no private right of action under the LIA. His sole remedy, the judicial remedy, is under FELA, and that's against the railroad carrier. We also have a broad tort immunity, and these are tort claims. As the trial court correctly found, we have common law claims here for indemnity, contribution, and negligence per se. Those all originate under state law, and they're state common law claims. And we have seats and component manufacturers have immunity, broad immunity from tort liability. The Forrester case from the Ninth Circuit in 2001.
So the remedy for the railway is under a breach of contract. It's if your client provides equipment that's clearly they're negligent in manufacturing the equipment, and there's absolutely no question that they were negligent in manufacturing something. What's the railway's remedy?
Well, let's talk about why we do have stops on ourselves first, the seats. There are significant penalties that can be administered by the Secretary of Transportation and they're referred to in the law case.
Does railway not have? So I'm just my hypothetical. There's just absolutely zero question that the seat was manufactured incorrectly. The railway doesn't, and the railway has now suffered a huge loss. They're liable under a FELA claim. They have just zero remedy.
Well, it depends. BNSF is fortunate in this case because they have a contract with General Electric Transportation Services for maintenance of their programs to make sure that all their rail cars, their locomotive.
My hypothetical is your company clearly negligent in manufacturing and installing, and they're the only ones involved. So does the railway have any cause of action
Against us?
Yes.
The railway would not have any sort of tort liability based on design defect against.
Well, this isn't tort liability.
Huh?
This isn't tort liability.
Well, the
this
underlying-
is indemnity. This is a third-party complaint, right?
It's a cross claim.
Well, I'm sorry, cross-claim. But this isn't tort liability in the sense that a state law tort needs to be proven. It's indemnity for liability incurred under a federal standard, under a federal law to a third party.
Well, let's look at the underlying claim here, because it has to be a flow-through from Mr. McKinney. And Mr. McKinney's claims were for design defect, manufacturing and design defect. BNSF, if you look at the second amended complaint, paragraph 45, he says the injury, the seat broke because of a design and manufacturing defect.
So under your argument here, the railroad company has no right of recovery against seats under any theory.
Correct. Under this fact scenario, it does not. Our penalties would come from the Secretary of Transportation, which could be up to $25,000 per violation, which is per day. And we also have, if it's something that could cause imminent injury, and the Secretary of Transportation looks at it, can be $100,000 per day. Each separate day is a separate violation. So we face severe penalties for a product that is defective, but that comes from the regulatory focus of the Secretary of Transportation.
If the executive branch decides to act, you face severe penalties. But otherwise, you could put firecrackers in the seats and face no liability at all.
Well, as Justice Kagan said in her dissenting or her concurring opinion, you know, she said, I doubt that Napier would be decided the same way today on field preemption, but it still exists. Our view of modern field preemption, we're a little bit tougher, but we have it. And she said, viewed from the lens of modern preemption, Napier is an anachronism. But
Okay.
she said, if it's going to change, and if you're going to get the remedies you think, she said, Napier governs so long as Congress lets it.
Does that mean the answer to my question is yes?
Which was your question? I'm sorry, Your Honor.
They could put firecrackers in the seats, and unless the Department of Transportation decides to intervene, they're immune.
That is the regulatory structure that the Department of Transportation, if we were to so recklessly build something, and each day that was in commerce, we could be fined $1,000 per day.
Okay.
But yes, there is no tort liability to
Does the
BNSF.
Does the record indicate whether the agency's taking steps to impose fines on your company, on your client?
To date, there is nothing in the record that would indicate there has been fines levied against our client in this case.
Is there a time frame for them to so act?
I don't know the specific time frame for them to act, Your Honor.
If the complaint had alleged, instead of because of a design or manufacturing defect, it had alleged because the seat was unsafe within the definition of the LIA, would there be a problem?
If the underlying claim of McKinney,
No. The language that you've highlighted on your
Right.
chart there, if that were couched in terms of the federal standard expressly, would there be a problem?
if the complaint said that there was a violation of the LIA standard,
The seat failed to meet the safety standards required by the LIA. If that was the allegation, does that pass muster?
no, it does not.
Why?
Certainly, the plaintiff would not have a claim. Plaintiff's only remedy is through FILA against the railroad carrier.
No, I'm sorry. I understand plaintiff has a claim under FILA against the carrier. My question is, if the indemnity allegations consisted of an allegation that the seat failed to meet the federal standards, rather than something that sounded a little bit more like state product liability law, could the indemnity claim survive?
No,
Why?
not against the railroad, because, Your Honor, if this is the indemnity standard, and that is it is so nebulous, the courts have held, that you will get a patchwork of different results and different interpretations from state court juries deciding whether our shock, bracket mechanism was unsafe or dangerous.
Aren't you getting that same patchwork just in determining liability under FILA if they're showing a violation of the LIA to establish negligence per se? I mean, aren't juries assessing that now?
No, because right now you're only dealing, because FILA is only against railroad carriers, and that has to do with their duty to maintain and to inspect the rail cars each day to make sure that they pass this test. Now, that does not contemplate locomotive component manufacturers. You just have the duty to maintain, and the Kilgore case and others have said a railroad carrier's duty to maintain and inspect is not part of LIA preemption. It gets more complicated when you bring in us, a component manufacturer, to these lawsuits, which are and then have design and manufacturing responsibilities, unlike BNSF. So once you bring that in...
Isn't the theory here that the seat wasn't in proper condition and safe?
Well, the underlying theory is they said that we had a manufacturing defect.
Well, no, isn't the plaintiff's theory that the seat wasn't safe?
Correct. That's part of it, and then he told us why it was unsafe.
Okay, but let's just start with the allegation that it was unsafe. If it's unsafe, and it's proven to be unsafe, that fails to meet the LIA standard and gives rise to liability under FILA, right?
If that was all proven by Mr. McKinney against BNSF in the underlying trial, yes.
Right, and that could be proven in any number of federal districts around the country with their widely diverse juries.
Yes, and that would be dealing with maintenance and inspection. It would not be dealing with a component manufacturer's duty to design.
It would be, under the express language of the statute, it would be dealing with proper condition and safety.
Right. It's not a manufacturing defect issue, because FILA does not contemplate. If you change this, you're going to do two things that Congress did not anticipate. Congress had said there would be no private right of action for violation of the LIA. If you go this way, you're opening up. There are private right of actions for everyone. Congress also said, specifically drafted FILA as applying only to railroad carriers and not to manufacturers. So these decisions are gutting Congress's intent on two forms with respect to LIA and FELA. And if there are problems with how this turns out, as Justice Kagan said in her concurring opinion, it's been like this for 90 years. And if Congress thinks that there is, should be a remedy, it's up to Congress.
What's your response to the Third Circuit's citation to, I think is it Ayers that at least refers to the Engvall case and seems to recognize its rationale?
If Ayers had anything to do with the LIA, it might have some impact. You won't find the LIA mentioned once in Ayers, not once. It has to do with contribution between a railroad and non-railroad employers. And the issue in Ayers had to do about, does a jury need to apportion that up front against the railroad to take into account how much should go to the auto body shop that had asbestos? And they said FELA still says the railroad employee can collect all from the railroad, but then there can be apportionment. And in that case, against non-railroad employers, it doesn't have anything to do with the LIA. And you can't find a mention of it anywhere in the entire case.
Could the parties have avoided this whole legal controversy by putting an indemnity clause in the purchase contract?
Well, that is another thing. We don't have any contractual remedy with any of these parties. The NSF has a contractual remedy, I assume. Well, at least they have their maintenance agreement through General Electric, and the manufacturer of the locomotive in their contracts, if they wanted to protect themselves with indemnity clauses and such, they could have done that.
Well, but I think Judge Winthrop isn't asking about what happened in this transaction, but whether such an indemnity clause would be enforceable.
Well, if there's a direct contractual relationship that deals with this situation, that is certainly a better argument
than a lot of the cases have dealt with tort liability.
Well,
And this is
it's
a tort.
it's an even more dangerous argument in a way, isn't it? Because contract law is state law.
Contract law between the parties, if they mention specifically indemnification for a product, and even Mr. Thorpe was saying, yes, they can sue for breach of warranty if a claim is for a warranty. If they had been provided a product that they thought was a breach of warranty, Mr. Thorpe says they could have sued for that.
And what do you say?
They certainly could have raised the argument. It certainly avoids tort liability issues.
So a claim for a breach of express warranty is viable, but implied warranty is not?
Well, that would be part of their contractual claims. I don't know how, we're dealing with hypotheticals here and what the contract may or may not include, but the cases are quite clear that you would not have, and that locomotive manufacturers have a broad immunity from tort liability, and that's clearly what this is in this case. Thank you.
I reserved all 1 minute, so I'm going to try to talk quickly and just hit 4 real quick points. To your question, Judge Swan, yes, the indemnity allegation set forth in the cross-claim here specifically alleges a breach of the Locomotive Inspection Act against seats, and that relates to the securely mounted and braced CFR that we've all been talking about. That is exactly the allegation in this case, in the pleadings, is the same allegation that is in the Needler case. Number 2, he's not really talking about preemption at all. He's talking about immunity, and there is suit from anybody for anything. And there's no indication anywhere that Congress passed the LIA thinking a manufacturer could violate it with impunity. And that's what he's telling you, with no consequence whatsoever. There's absolutely no evidence of that in their record. Third, he says that, Ayers really doesn't relate to this. Ayers cited to Engvall for the following proposition that talks about, quote, FELA defendants may bring indemnification and contribution actions against third parties under otherwise applicable state or federal law. Cite Engvall. Federal law is the LIA when you're talking about railroads, among others. So that's the last point is he talked about Bonner, says that juries will get confused. Bonner was an unpublished Arkansas district court case, where I think it's Arkansas, and the court doesn't even reach the issue because they say nowhere in this statement is the court able to discern an argument that EMD violated the federal standard imposed by LIA. In other words, they didn't allege an LIA violation in Bonner. The case law from the major courts all supports the position we are advancing. Thank you.
Thank you both for your arguments. We'll take this matter under advisement and issue a decision in due course. And with that, we'll take a brief recess.